shut off. I can visualize you have your tea now, and we're good to go. So, going back to the slides, please. Royal decree, the first royal decree. All the way to, no, royal decree. So those first slides you were going through. That one. Okay, so the first one is presumption of innocence and protection from unjust detention. Many of you will say, well, Queen Romana, we already have that. Not by me, not a royal decree issued by me, and not under natural law. This is under natural law. Okay, so royal decree of the presumption of innocence and protection from unjust detention, issued by Her Royal Majesty Queen Romana Didulo I. So remove the slides and put me back. Thank you. All right. Royal decree issued by Her Royal Majesty Queen Romana Didulo I in the name of the Crown, that's in the name of the Kingdom of Canada and we the people of the Kingdom of Canada. Under the principles of natural law, all of the royal decrees we are reading today are under natural law. The Kingdom of Canada's legal foundation is natural law, not common law, not civil law, not maritime law, natural law. Section 1, presumption of innocence. All nationals, all persons are presumed innocent until proven guilty of a crime, and no person shall be imprisoned or otherwise deprived of liberty prior to a fair and public trial by an impartial tribunal or competent court under natural law, let that sink in. You see, you have had incidents, and I'm sure many, where someone in private uniform, masquerading in corporation uniform, masquerading as the We the People's police officers, they knock at your door and say, we have a warrant to arrest you. And then they handcuff you and take you away. That's in the old system. They were allowed to do that. What that was the equivalent of is kidnapping. Let that sink in. Number one, you have not been tried and proven guilty in the court of law. Why are you being handcuffed and why are you being imprisoned? So they handcuff you, put you in their vehicle and take you to their precinct. That's kidnapping, one. Number two, they say, you will stay here while we do your paperwork. What is that? You're under duress. You are amongst individuals who have guns, and you have no control as to what they're going to do to you. What is that? That's kidnapping. Then they say, here's the paperwork. You sign here, you sign here. And we will not release you until you have signed. And we will, that's step number two. And if you do not sign, they won't release you. What is that? Extortion, is it not? They're extorting you for your signature. Remember, until this time, you have not yet been tried and found guilty. Next, they say, we're going to present you to a judge. in the next whatever, how many hours, so that you can plead guilty or not guilty. That's extortion number 2. You're under duress. You're in their custody. You have not yet been tried and proven guilty or convicted guilty. So where's due process? 0. Right? So this section here, the section 1, presumption of innocence. No one should be handcuffed. No one should be imprisoned, regardless of whether it's about minutes or 3 hours or 32 hours or 72 hours. You have 0 legal basis to imprison anyone at that time. If you're talking about fair and just and proven and protection of innocence until proven guilty, handcuffing them equals to kidnapping. Taking them away from their home, that's kidnapping. Taking them to the precinct, that's kidnapping. Forcing them to sign paperwork, that's extortion. If they don't sign, you keep them there for as long as you wish. That's bribery and extortion. You sign here, we'll let you out. If you don't sign here, you won't get out. I don't think anyone really has explained to you how legal system should really work. So all this time, the presumption of innocence was simply a lip service. So section 2, no pretrial detention without a just cause. Note number 2, no pretrial detention without cause, meaning you cannot detain someone before trial. Again, because that's kidnapping and extortion. They have not been convicted of a crime. So there's no reason for them to be imprisoned, is there? So no individual shall be detained before trial except in cases of extraordinary justification, such as to protect public safety. That's the only exception there. The exception before, they say, well, they may not show up in court. That's not enough to imprison someone. Oh, they may fly, get on the aircraft. That's not sufficient to imprison someone. That just means that your CBSA, your immigration department, needs to talk to your immigration people to make sure that that individual doesn't fly out of the country. Okay, so I will repeat number 2. No pretrial detention without a cause. No individual shall be detained before trial except in cases of extraordinary justification, such as to protect public safety. Such detention must be 1, authorized by a verified and certified statement of complaint. There has to be someone who made an official and verifiable complaint. The complaint cannot be made up by someone. And subjected to, okay, so this one, Number one, it says such detention must be authorized by a verified and certified statement of complaint and subjected to pre-judicial review by a court of competent jurisdiction under natural law. Meaning you need two things. Number one, a certified and verified complaint. So there has to be a Homo sapien. Remember that a police officer works for the courts, the judicial system. They cannot be the complainant. So when you have a police officer or an RCMP making a statement, that's not enough. That is actually now the process is tainted. Because they're there to execute the judicial order, not to be the complainant. Capiche? Capiche? And this section 2 emphasizes that any pre-trial detention must undergo pre-judicial review, a legal term referring to a court's examination of the legality of detention under the principles of natural law, ensuring that the detention is both lawful and just. So before you can go arrest someone, you have to have a complainant. The complaint has been verified and reviewed by a judiciary official. And that includes evidence. You cannot go handcuff someone based on a hearsay. And you cannot go handcuff someone because somebody in uniform officially made a statement. No, you are not a complainant. You're there to execute the judicial system's order. You cannot handcuff someone unless you have a judicial order. Section 3, verified and certified statement of complaint. A verified and certified statement of complaint must be submitted to the court prior to any pretrial detention. This statement must be signed by 2 authorized law enforcement officers and 2 judicial officials, and must contain sufficient evidence beyond reasonable doubt to justify the detention under the law. Let that sink in. A verified and certified statement of complaint must be submitted to the court prior to any pretrial detention. This statement must be signed by 2 authorized law enforcement officers and 2 judicial officials, and must contain sufficient evidence beyond reasonable doubt to justify the detention under the law. So you need 2 judges to sign, to have verified the complaint, to have verified the evidence being presented, and must have 2 law enforcement officers. So you have 4 people. You must have 4 to even complete this process before you can handcuff someone, before you can detain anyone, before their trial. So Section 3 emphasizes the importance of verified and certified statement of complaint as a safeguard against arbitrary detention, reinforcing the rule of law and individuals' rights in the Kingdom of Canada. So thuggery ends. Hearsay ends. the oppression ends. So politicians, the select few, cannot call their buddy who's in uniform and say, go harass somebody, go handcuff that individual. And then they handcuff, take them to the precinct for fun. And then the case is dropped because there was no evidence to begin with. So I'm ending that kakistocracy. We the people, you have to know your rights under the law. And to the police officers and the RCMP and the law enforcement officers, including the military, under natural law, you must follow these procedures. Otherwise, you'll be charged with kidnapping and extortion and bribery. Number 4, due process and legal rights. Any detention must be accompanied by due process, including the right to be informed of the charges, the right to legal counsel, and the right to a speedy and public trial. There is no private trial. Everything is public. That means the courthouse, under natural law, is open to the public. Section 5, financial transparency and accountability in court proceedings. Each court involved in any case must provide a verified and certified financial accounting records and list of all third parties involved to the complainant, to the plaintiff, and the public, especially those benefiting commercially and financially from the court case, in accordance with the principles of transparency, accountability, and natural law. This is for the very first time under natural law, the courthouse will be required to provide an accounting record for every case that they're trying. For everyone who has been arrested, they must provide accounting records. Who's being paid? Who's benefiting? Was there a bond issued after they obtained the signature of the individual they have just arrested? And where is it being traded? Is it being traded in the stock exchange in Toronto, in New York, in the NASDAQ, in Chicago? Where? London? So we the people, and this accounting records must be made available to the public upon request. So Section 5, I will repeat. Financial transparency and accountability in court proceedings. Each court involved in any case must provide a verified and certified financial accounting record and list of all third parties involved to the complainant, the plaintiff, and the public upon their request, especially those benefiting commercially and financially from the court case. So, lawyers, the court, do they monetize the signature? Do they monetize the case? Do they create bond out of every signature of the defendant and the plaintiff? So the lawyers, the judges, and the police, they have to have accounting records, because you see those systems work in tandem, right? You have to have a police there that did the arrest, and then you have to have the lawyer there who is either defending or prosecuting, and then you have the judge, and then who else is benefiting? And are they tapping on the straw man, the trust created at birth? Are they being paid? Are they tapping that? So any trust account involved must be presented here also during this financial disclosure by the court. Are we clear on that? Section 6, Enforcement and Accountability. This decree shall be enforced by all branches of the Kingdom of Canada's government, and any violation shall be met with legal and criminal and moral accountability in accordance with the law under the principles of natural law. So the gravy train is over. Section 7, Sovereign Authority. This decree is issued under the sovereign authority of Her Royal Majesty Queen Romana Didulo I as the official reigning monarch of the Kingdom of Canada, effective forthwith. Retroactive, July 1, 1867. In witness whereof, I have hereunto set my hand, my royal hand, and the great seal of the Kingdom of Canada. This day, 27th, DIVINA Industria, year 0035. In the 3D world, May 25th, 2025. And given under the royal seal, Her Royal Majesty Queen Romana Didulo I. Signed and sealed. Your Excellency, Darlene Ondi, you may go through the rationale of the royal decree. Go ahead.
All right. Thank you very much, Your Royal Majesty. So this is the rationale for
So one moment, Excellency, if you can put up the rationale there on screen. So that one, yes. Okay. Go ahead, Your Excellency.
Thank you very much, Your Majesty. So this is the rationale for presumption of innocence and protection from unjust detention. So number 1, upholding natural law principles.
Okay, and I will read the expanded explanation to that. So upholding natural law principles. Natural law is grounded in the belief that certain rights are inherent to all human beings, regardless of legal systems or governments. By issuing this royal decree, Her Royal Majesty Queen Romana Didulo I affirms the inviolability of the individual's liberty and the right to due process as universal and moral imperatives.
All right. Number 2 is reinforcing constitutional values under natural law.
Remember that I'm drafting the Constitution of the Kingdom of Canada under natural law. Actually, it is complete, as well as your Charter of Rights and Freedoms under natural law. I am going to release that at the most appropriate, opportune time, as they say. Okay. So, reinforcing constitutional values under natural law, the Kingdom of Canada's Constitution and Charter of Rights and Freedoms under natural law already enshrines the presumption of innocence and protection from arbitrary detention. This decree aligns with the reinforces those values, ensuring they are upheld with moral and legal clarity. So I just clarified to you what had been done versus what really is due process and what is kidnapping that was incorporated, embedded into the process. And I'm sure that many of our brothers and sisters, the police officers, the RCMPs, the law enforcement officers, and the military, it became a norm. And of course, they were working for an old system that treated everyone as if they were lost in the sea, not as if they did. Okay, go ahead.
Number 3 is preventing abuse of power.
That's where we're getting at. This all had to do with the abuse of power. By requiring a verified and certified statement of complaint before pre-trial detention, the decree acts as a safeguard against misuse of state authority, ensuring that detention is not used as a tool of oppression or political control. The abuse of power, as I had said earlier, you would have some politician that would call up their buddy friends in uniform and say, go harass someone. Just for fun. Take them to the, the detention center. Make up a story. Get a warrant. Call our buddy Bob there. He will give, he's a peace, justice of the peace. He'll sign it for you. Just knock at his door. Put the piece of paper, he'll sign it and send it back to you. Then you can go into your police car and arrest someone, handcuff someone. That was abuse of power. This is why I have issued this royal decree to put an end to that kakistocracy. Okay, go ahead, Your Excellency.
All right, number 4 is promoting justice and fairness.
Okay, so number 4, the decree reflects a commitment to justice, transparency, and the rule of law, ensuring that no person or no individual is deprived of liberty without due process, evidence, and judicial oversight. So those who, created and issued false narrative about Queen Romana, making a list, on a kill list or something.
Execution list.
Execution list. Remember, there's due process. That just tells you, you know nothing about Queen Romana. 0. So your fake narrative, your fake news is just that, fake news. All right, number 5.
Number 5 is sovereign duty and moral leadership.
Okay, so number 5, as the reigning monarch of the Kingdom of Canada, Her Royal Majesty Queen Romana Didulo I has a sovereign duty to uphold the rule of law and moral order. This decree serves as a moral and legal statement of Her Royal Majesty Queen Romana Didulo I's commitment to justice, liberty, and the protection of individual rights within the Kingdom of Canada. And the conclusion to that, this decree, rooted in natural law, serves as both a moral mandate and a legal reinforcement of the rights and freedoms guaranteed to all Kingdom of Canada's nationals in the Kingdom of Canada. Okay.
Right. And that's all I have for that one, Your Majesty.
Yes, that's all. I just placed 5 rationales there. I can go on
and on, yes.
and on and on. Okay.
So I would like to just make a couple of comments, if I may, Your Royal Majesty. So it sounds like the previous judicial system will need to do work, but they'll have to work actually now to.
Well, they
move
have
forward with
zero
anything.
authority under natural law. Because remember that the old system, you had a lawyer for the plaintiff and you had a lawyer for the defendant. And then you had a judge. All three were under the bar registry regulations. And the bar regulations, their professional regulations, came first. This is why some of the lawyers would withdraw from a case when they saw that the case would have questioned the judicial system and would compromise the entire system as a whole. Instead of defending the rights of their client, they would withdraw from the case. Because number one, the same system that was upholding the judge or was governing the judge was governing the defendant's lawyer and the plaintiff's lawyer. So what do you have there? Where is fairness and justice there? And the Bar Association, the Bar Registry, did not report to the public. They were a private transcontinental organization. That was a club.
Mm-hmm.
So where's justice and where's fairness? Who do you think that we're going to protect? Their system or the individual's rights? Because if the lawyer proceeded to defend the client's rights and would compromise the bar registry, then he or she gets disciplined and they lose their license to practice law. So that in itself is already compromised. No one received fair and just trial because it was another kabuki, Japanese kabuki show, a complete shenanigans, an illusion of justice.
And gone are the days of the Zoom courts, I'm going to say, because, if they didn't like something that was heard, they just had some sort of technical difficulty and there went your case. So all that kakistocracy is done, all those deals done on the golf course and everything else are done. It was a financial transaction and never in the benefit or in the favor of those they were charging.
Correct.
So thank you so much for that powerful royal decree, because we have never had such accountability and transparency, and I'm sensing there's probably some very nervous, uncomfortable judges and lawyers out there at the moment. And
also your courthouses. They now have to disclose their financial dealings. Number one, they're being funded by the We the People, so how come they're charging the We the People? You take a form, they charge you. You fill out a form and file something, they charge you. Wait a minute, are you not being funded by the public already? So there goes the double dipping. This is why the royal decree requires every court case. So that's every courthouse, every court case, they have to provide financial accounting. They too will be, are subjected to financial forensic audit. Okay.
A few uncomfortable moments there, I am certain. Shall we move on, Your Majesty?
Oh, yes.
Or do
Go
you
ahead.
have anything else?
No. So I'm just encouraging we the people in the Kingdom of Canada and around the world. Know your rights. Know your rights. And to the police officers, the RCMPs, and the law enforcement officers, also know your rights. Before you handcuff someone, make sure you know. Make sure you have 2 judges and another officer with you to verify that what you're doing actually is lawful, is legal, because you will be charged with kidnapping. The individual that you're handcuffing has the right to sue you for kidnapping because there's no due process there. You cannot go imprison someone. You go around the world and you do that to someone and they'll charge you with kidnapping and extortion.
Incredible. All right, so Your Excellency, if we can bring up the next royal decree we're going to be going through, please and thank you.
Okay.
So back